2015-16 ಇರಬೇಕು, somewhere around that time, 16. ಇವಾಗ್ಲೇನೆ ಹಾಕೊಂಡು ಮೆರವಣಿಗೆ ಮಾಡ್ತಾರಲ್ಲ ಹಾರ, ಆಪಲ್ ಹಾರ, ಹಂಗೆ ಅವನು ಮೆರವಣಿಗೆ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲಿಂದ ಧಾರವಾಡ ಜೈಲಿಂದ ಕಲಬುರ್ಗಿ ಇದು ಹುಬ್ಳಿವರೆಗೂ ಓಪನ್ ಜೀಪ್ ಮೆರವಣಿಗೆ, as if he has fought the Kargil war and then triumphed from there. Only 2 days, sir. 42 stab injuries on the body at 11 a.m. in the most busy area of Hubli called Kamripet. 48 stab injuries. Nobody went to his rescue. ಲಾಯರ್ ಓಡಾಡ್ಕೋತ ಬಂದ್ರು, ಇನ್ನೇನಪ್ಪ ಬಂದ್ರು ಇವರು ಅಂತ ನೋಡಿದೆ ನಾನು. ಸಾರ್ ನೀವ್ ಹೇಳಿದ್ದೆ ಕರೆಕ್ಟ್ ಆಗೋಯ್ತು ಸರ್, ಇವತ್ತು ಹೊಡೆದಾಕ್ಬಿಟ್ರು ನಮ್ಮ. I told him, your client is safe in judicial custody, let him not come out. Sometimes ಆಗತ್ತೆ, ಇವನ್ಗೂ ಪಾಪ ಗ್ರಾಚಾರ, ಸುಮ್ಮನೆ ಜೈಲಲ್ಲಿ ಇದ್ದಿದ್ರೆ ಬದುಕವನು. ಅಪ್ಪು ರವಿವರ್ಮ ಅಲಿಯಾಸ್ ಅಪ್ಪು. Now you see, let the eyewitnesses be examined, you can renew it later. Barpali. What can be done if he is not available? No, ಆ ವ್ಯಕ್ತಿ ಅಲ್ಲಿ ತನಕ ಇದ್ರೂ ಇವ್ರು ಮಾಡ್ಕೊಂಡಿರ್ಲಿಲ್ಲ ಅಂತ ಯಾರು ಹೇಳ್ತಾರೆ? ಅದೆಲ್ಲ ತಾವ್ ಕೇಳಿ, ಐಒನ ಬಂದಾಗ ಕೇಳಿ. ಐಒ ಬರ್ತಾರಲ್ವಾ, ಈ 3 ತಿಂಗಳು ಬಿಟ್ಬಿಟ್ಟು ಯಾಕೆ ಇನ್ನೊಬ್ಬ ಐ ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ರಿ ನೀವು? ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳಕ್ ಯಾಕೆ 3 ತಿಂಗಳು ತಡ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ನು ಹೇಳ್ತಾನೆ, ಅವ್ನು ಕಾಶಿ ಯಾತ್ರೆಗೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ದ ಅಂತ. See, these are all not the grounds for granting the bail in a 302, sir. What is this? You argue on the substance of the matter. What is the recovery from you? Where were you at that point of time? Admittedly, the deceased was also an accused in a murder trial, and he was enlarged on bail about 2 years earlier. There is an enmity, group clash, and this man has been killed now. ಬೇಡ ರೀ, ಅಲ್ಲಿ ಜೈಲಲ್ಲಿ ರೀ, ಸಂತೋಷವಾಗಿರ್ತೀರಾ, ಹೊರಗಡೆ ಬಂದ್ರೆ ಹೊಡೆದಾಕ್ ಬಿಡ್ತಾರೆ ಅಂದ್ರೆ, ಇಲ್ಲ ಸರ್ ನಾವು ಐ ವಾಂಟ್ ಟು ಎಂಜಾಯ್ ದಿ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಅಂತ. ನೋಡಿ see now, in a given case at Dharwad, I told, ಬೇಡಪ್ಪ ಇವೆಲ್ಲ ನಿಮ್ಗೆ ಅಂತ. Man from Hubli came, an advocate from Hubli came. I was in charge, concurrent charge holder of Hubli court also, because the judge there was retired. Then I told, your client is better, he is safe in judicial custody, let him not venture any of these things. Anyway, your bail request earlier with the earlier district judge is rejected. Now that man is retired, therefore you have come to me. He insisted, no sir, no sir. With some amount of reluctance, it was a case for granting. It was not a murder trial, it was just a 395. So I said, fine, if you want, we will consider it on merits, and I granted the bail. On the day of granting also I told, let your client be careful, let him not indulge in all these things. Heard. ಇಂಥವ್ರಿಗೆಲ್ಲ ಯಾರು ಸಪೋರ್ಟ್ ಮಾಡೋದಿಲ್ಲ. ನೋಡೋಣ, ಗ್ರೂಪ್ ಕ್ಲಾಶ್ ಎಲ್ಲ ಗ್ರೂಪ್ ಕ್ಲಾಶ್. Heard C. Mahesh Kumar and learned HGP. Petition under section 439 CRPC with the following prayer. Brief facts of the case are as under. Complaint came to be lodged by Sri Babu M, son of Muniswamy, with Ashok Nagar Police on 20th April 2021, which was registered in crime number 90/2021 against unknown persons for the offence punishable under section 143, 144, 145, 146, 147, 148, 302 IPC, read with section 149 IPC. Gist of the complaint governments revealed that on 20th April 2021 at about 10:30 a.m. when the complainant was taking dinner in his house, somebody telephoned to his another son stating that some unknown miscreants have assaulted his son by name Ravi Varma alias Appu near Muneshwara temple. Posta. Immediately, himself and his other children along with wife proceeded to the place near Muneshwara temple and saw his son Ravi Varma having fallen down in pool of blood. Posta. Police had already arrived on the scene and on seeing the place of incident, and inquiring with the persons who had assembled there, complainant came to know that a group of 7 to 8 persons had assaulted Ravi Varma with machete and other weapons and had ran away, and Ravi Varma alias Appu had breathed his last. Posta. Based on the complaint, police registered the case against unknown persons at the first instance and investigated the matter in detail. Posta. In the course of investigation, present petitioner was apprehended and his voluntary statement was recorded. Based on his voluntary statement, a knife has been recovered from the custody of the petitioner. Posta. Next para. After thorough investigation, police filed charge sheet against the petitioner and others. Posta. The attempt accused is shown as accused number. Present petitioner is shown as accused number 6 in the said petition in the charge sheet. Accused number 11 in the said charge sheet. Posta. Next para. Accused number 11 as in the charge sheet. Posta. Next para. The attempt made by the petitioner to obtain an order of bail is rejected by the learned district judge on 25th July 2022 in semis number 255/80 of 2022. Thereafter, petitioner is before this court. Next para. Reiterating the grounds urged in the petition, Shri Mahesh Kumar, Lord Counsel for the petitioner, vehemently contended that petitioner is innocent of the offences alleged against him and he has been falsely implicated on account of the previous enmity and therefore sought for grant of bail. First, he also pointed out that after recording the statements of the two of the eyewitnesses, the investigation agency, after a lapse of 3 months, records the statement of yet another eyewitness, which exposes the hollowness, HOLLO, hollowness in the case of the prosecution and sought for grant of bail. First, he also pointed out that since the recovery is already made and charge sheet is filed, continuation of the accused petitioner in judicial custody is no longer warranted and sought for grant of bail. Next para. Per contra, learned HGP opposes the bail grounds by reiterating the contents, by reiterating the grounds stated in the objection statement. First, he further contended that petitioner has been arrested based on the material collected by the investigation agency and on the statements of the eyewitnesses. First, he also pointed out that the material on record at this stage and the word tag that is alleged against the petitioner is sufficient enough to form a direct nexus between the incident and the homicide, between the homicidal death of Ravi Varma alias Appu and the petitioner. First, he further pointed out that recovery of the knife at the instance of the on the basis of the voluntary statement of the accused petitioner fortifies the case of the prosecution and sought for rejection of the bail. First, next para. Any of the rival contests of the parties, this court perused the material on record meticulously. On such perusal of the material on record, it is seen that initially the case came to be registered against unknown persons. First, after so registering the case, police thoroughly investigated the matter. First, during the course of investigation, police were able to record the statement of the eyewitnesses who have seen the incident. First, no doubt, one of the eyewitnesses, namely CW, ಅಲ್ಲ 3 ತಿಂಗಳು ಬಿಟ್ಟು ಹಾಕಿದ್ದವರು No doubt, after lapse of 3 months of recording statement of CW 6 and 7, statement of CW 8 is recorded by the investigation agency. Posta. Whether at all there is a delay on the part of the investigation agency in recording the statement of the eyewitness and how far it has affected the case of the prosecution is a matter that has to be decided by the learned trial judge during the trial. Posta. Next para. Suffice to say that the present petitioner, after having been apprehended by the investigation agency, gave a voluntary statement, and based on such voluntary statement, the investigation agency is able to recover a knife said to have been used in the incident. First, whether at all the present petitioner was really involved in the incident, and he has also assaulted the deceased with the knife, resulting in the homicidal death of the Ravi Verma alias Apu, or not, cannot be decided by this court at this stage by holding a mini trial, as the same may prejudice the case of the parties during the trial, one way or the other. First, next para. Thus, desisting from holding a mini trial, when the material on record is appreciated for the sake of consideration of the present bail petition, this court is of the considered opinion that the material on record in the form of charge sheet is sufficient enough to deny the bail for the petitioner by resorting to the special powers vested in this court under section 439 CRPC, especially in view of the recovery of the knife from the custody of the petitioner said to have been used in the incident. First, accordingly, it is next para. It is always open for the petitioner to renew his request for grant of bail with a successive bail application of the material after the material witnesses are examined on behalf of the prosecution, and if there is a positive change in circumstance. First, next para. Reserving such liberty for the petitioner, following order is passed, bail petition rejected.
My lords, I'm appearing for the petitioner, serial number 41, my lords.
Yes.
Kindly, my lords, I have given NOC in this matter, my lords. I will file the necessary application, memo of retirement in the registry, my lords.
Today itself.
My lords, tomorrow, my lords.
If you don't file it today, I'll dismiss it for non-prosecution. Matter is pending since 2022.
Please, my lords. Please, my lords.
Pass over.